Immigration updates and live questions from 5 p.m. to 6 p.m. every Tuesday Central Time. Emily, what do we have today?
Today we want to talk about the new H-1B lottery system, the beneficiary-centric system that is supposed to reduce all of those duplicate filings, what that timeline looks like, what the process is going to look like this year, how it's different from last year. And then we're going to talk about that online I-94, where you go to the CBP website, enter in your passport information, and it gives you your I-94 number, your date of entry, what status you were admitted in, your expiration date. There's a lot of confusion about this when it comes to filing an extension with the Immigration Service and how it interacts with your I-797 approval notice, as well as advanced parole. That's very confusing because you get all kinds of different dates with advanced parole travel. So we'll talk about that. And then how to handle a rejected H-1B transfer. What are the steps and options if you have filed a transfer? What happens if you get a denial, whether you've joined the company, if you haven't joined the company, what if you were in your 60-day grace period? We'll try to answer some of those issues and what options you might have. Lastly, we'll talk about maximizing your H-1B with that 6-year limit. Make sure that you understand what your 6-year limit is, how to calculate it, how to extend beyond it, and what are all of those options to get back on H-1B if you decide to leave the country.
Emily, first of all, everybody knows that on March 6th is where the registration starts. Did we have instructions already given for the employers to register their companies yet? If it's not, when they can start registering the company? And March 6th is the first day to file the lottery system, but the end date is March 22nd. What exact timing is it on March 22nd? And can you explain that process, Emily?
Yeah, so first up, it's a brand new online platform which no one has access to yet. USCIS will give us access starting February 28th, so employers will be able to create their employer account. However, for our clients, we're not recommending that the company go in and create their account until we have a chance to create our account and send them an invitation. Because if we do it that way, the company account as the attorney will be linked very easily because we have to log back into our My USCIS account, and it's going to automatically, magically become this new platform, and then we're able to actually somehow connect it with a company account. Versus if the company goes in on February 28th and creates their own account without having the attorney information, we don't know how simple that connection process is going to be, and we don't want to be messing with that for the next 6 days when we should be getting ready to actually submit the registration. That's number one. For our clients, at least, we're recommending employers don't do anything until we let you know it's time to do something. And then, yes, the registration window itself is from March 6th, starting at noon Eastern time, to March 22nd, ending at noon, and that's Eastern time. So if you're in Central and it's 11:05 a.m. and your registration has not been submitted, it's over. So you need to take that into account, especially if you're not Eastern time, so that you can get it submitted on time.
Emily, what time is better to file? If I get an extra chance, if I file on March 6th, or if I file on March 21st, or is it the same?
Same exact chances. I am not a fan of submitting on the opening day because there are always glitches, and I want to let everyone else figure out the glitches. I'll start maybe on the 3rd or 4th day and get all of mine done. And I definitely don't like to wait till the last day, because if there's any glitches on the last day, you don't have time to fix them. So don't start it super early. Don't start it super late. Anytime in between is good. Your chances are the same whether you submit it on March 10th or March 20th. So anytime between that window is the best time.
March 20th, guys, not March 22nd. Don't go there. I you stay within March 20th. From March 9th to March 20th will be the best time for you to file the application. Emily, I know you said that it's beneficiary centric. So we have seen that in previous years, the companies have filed, there are 7 companies that filed 500 H-1Bs for all 7 companies. Happens to be the lawyer is also the same one. Of course, they are prosecuting the lawyer and they're prosecuting the companies. That's a different issue. But is there any advantage right now for people filing for multiple applications to get extra chances in the lottery?
No. So even if you have 100 companies submit your name only goes in once. It does not provide you any extra chances. And honestly, it would be worse because if any of those 100 companies are not legitimate companies, which we saw quite a few of last several years, it could actually make things much worse. We're seeing revocations of cap subject H-1Bs for fraud, and it's causing people to get they're having trouble with stamping, they're having trouble with traveling. You're ruining your career and your life for nothing because you get no benefit out of that. So don't do it.
Emily, I have an offer from Apple and I have an offer from Google. Nice companies, and no fraud involved in nothing there at all. Can I, if I file with both the companies though, and I don't want to let any of the company know because I haven't decided which company to join yet. So if both Apple and Google files, when my name is selected, I know you told in the previous thing that I get to pick which company to go, but who will be notified? Will I be notified or will the companies will be notified? If the companies will be notified, with Google and Apple both get notified and telling that Google, hey, Rahul also has filed with Apple, and telling Apple, hey, Rahul has also filed with Google.
So what we think is going to happen is only the companies get notified. So if your name is put in with Google and Apple and your name gets selected, both Google and Apple get lottery selection notices in their company name. They do not, as far as we know, get any information about you submitting with the other company. So they're not going to be told that, Google's not going to be told that, hey, this guy also got a selection with Apple, because that's, violation of privacy. They can't share that information with an unrelated entity. So from my understanding, both companies will get the selection notice, and you could potentially file with both and get 2 H-1B approvals, but you're only taking one cap number when you do that.
Oh, somebody's correct me. It's not Google, it's Alphabet. Okay, that's fine. This, what you said, is what you think, Emily, but it's not certain, is it right, Emily? I mean, they haven't notified very clearly. Will they inform Google and Apple? It's just what you're estimating.
Yeah, I'd say 90% confident of that. I can't imagine that they're going to share another company's selection with a different company.
Well, they always do unpredictable things. Yeah, that's the way. Now let's move on to the next topic, Emily, the I-94, Emily. I get so many calls, and I know you get the calls too. Let's say, for example, I come in from India with a H-1B, and that is expiring in September of 2023. And my company has paid you money to file the H-1B extension. And you gave me the H-1B approval. And a lot of people are telling me that if the I-94 is not extended, I am illegal. Today, I found out, Emily, even though my company has paid you the money to get the H-1B approval, I see the online status that says it's still expiring September 2023. You did a mistake by not extending the I-94. Is that right?
No, thankfully, no. And you have to remember that I-94s are actually issued by 2 separate agencies. So the one that you get online is CBP. That's anything related to the port of entry when you're traveling into the country. The one you get when you file your extension, that's USCIS. They are separate agencies, and while they do somewhat talk to each other, the USCIS I-94 does not update the CBP I-94. So as long as you have an extended I-94 on your I-797 approval notice, that's your new status. You're extended properly. There's nothing that's going to change online until you travel again. The only time the online I-94 changes is when you travel. Now, advanced parole, how exactly does that work? Because I have this advanced parole document, especially when it's not on my EAD card. It's a separate document. It's got my picture down at the bottom, and in tiny print, it says when the expiration date of the advanced parole is. I travel in and I get a completely different date on my online I-94, and that they actually handwrite a different date on my document. And that's usually for 1 year. So if I'm being let in for 1 year on that online I-94, does that mean I need to file an extension after 1 year to be able to stay legally in the country?
Big mistake, Emily. There are a lot of people who are doing mistake. Your advance parole expires when it says it expires on the advance parole, not on the I-94 what it says. I've seen people who have got an advance parole, which, let's say for example, it's expiring in September of 2023. They traveled somewhere in July of 2023. The online I-94 said the advance parole expires in July of 2024. They came into United States and they let the advance parole expire because on the online it says July 2024. They left to India because they thought the online I-94 is the valid advance parole expiration. They were trying to come back. They were being deported, Emily, because they don't have a valid advance parole. Their advance parole expired in September of 2023. Now in January of 2024, they are trying to come back. They were being sent back to their home country. That's a big no-no. Whenever it's an advance parole, now this is only for advance parole, guys, not the other people. The expiration of your advance parole is on your document, not in the cloud. Well, you know, now people call internet and everything in the cloud, is that right? Not in the cloud. It is in your document. Your document tells you when the advance parole expires. That is what you're supposed to have it, not on that. You know, there are also people, Emily, have you seen that now from October of 2023, we are seeing people getting 5 years advance paroles, and they come and whine at me. So, Rahul, my I-94 advance parole is expiring in 1 year. My actual advance parole is expiring in 5 years. Which one is valid? The one that you have in the hand is valid. So please, in these two scenarios, though, where you file I-797 extension for H-1B, H-4, L-1, L-2, it's the document I-797. That is after you entered into the United States. The I-797 expiration, as Emily pointed out, is the expiration date. When it comes to the advance parole, it is the document that says when it is expires. It's not the I-94 that is online. Now, Emily, moving to the second topic, though, there is very dangerous topic that we see, the I-94 problems there. I have my I-797, I'm working with company A, and that company A stamping is expiring in September of 2023. I joined a new company in January of 2023, company B, and I got the H-1B approval until January of 2026. I traveled in July of 2023 using you told me, and a lot of other lawyers, nice, good lawyers, told that I can travel even though I changed from company A to company B. I can travel on company A's passport visa. You told, and your team told, and there are a lot of other lawyers told that I can travel that. I traveled outside the country. I'm here right now, and I see the I-94 expiring in September of 2023. I came in July of 2023. My I-94 expiring September 2023. Am I in danger?
Yes. Yes. When you're entering, you need to show both your visa stamp and your passport with the old company name on it and your new I-797 approval notice with company B that has the extended I-94 on it, and make sure that they give you the end date that matches your new company's I-797, not the visa stamp on your passport. So they're supposed to give you the full period of time that is on your I-797, not what's on your visa stamp. If they don't, and they give you the shortened date, that is an error. And in this situation, it would be an error. However, if you don't notice it until after it expires, you are out of status and you are unlawfully present. Do not go to CBP to ask them to correct it at this point, because they will deport you, because they're going to say you overstayed. You're not here lawfully. So be very careful, talk to a lawyer to figure out the right way to fix that situation. But the most important thing is anytime you travel and come back in, when you're a non-immigrant, check your online I-94, make sure you know what that date is. So if they do give you that shortened date, you can correct it before it expires, because there's lots of options when it's before it expires, but after it expires, there's a big danger there.
Emily, here one other scenario. My passport visa stamping is expiring in January of 2025. I came into United States in July of 2023. My passport, not the passport stamping, passport is expiring in September of 2023. But my passport visa with company A, and I never changed any company. I'm still staying with the same company that I came in, but I traveled in July of 2023. I came back, but I got and they did not give an I-94 until January of 2026, until when my visa stamping is expiring, but they gave only until September of 2023 because they looked into my passport, not my passport visa, and they gave it. Am I in danger right now?
Yes, that's also a big problem. And the scary thing is they don't tell you that they're doing that. They don't say, oh, hey, I see your passport's expiring before your visa, so I'm limiting your I-94. They don't tell you, they just do it. So again, when you come into the US, always check your online I-94, the first thing, so you know what that is. And that is their policy. When your passport is expiring before your visa or before your I-797, they will cut short your I-94. That becomes your new end date, even though you have this other document that has a longer validity. So you do need to take action before the new end date expires. There are lots of options there. Once you get your passport renewed, you could travel again, come back in, and now you'll get the full validity period. Or if you don't have the option to travel for whatever reason is going on with work or family, your company could file an extension so that you don't miss that end date, but you do need to be very careful about that.
Emily, remember, my I-94 expired in September 2023. We are in February of 2023. Can we file the extension right now, or what's the solution?
Yeah, so there's a big problem there, because when you overstay your I-94, you are out of status and you are accruing unlawful presence. So the only time you can now file an extension or even a change of status, filing anything with USCIS after your stay is already expired and you are out of status and unlawfully present, you basically have to make a nunc-pro-tunc request. This is saying, due to extraordinary circumstances, I did not file this on time. I'm asking you to use your discretion to overlook my delay in filing and put me back in status. So then it becomes very case by case specific, depending on the facts of your particular case. It needs to be well explained, well thought out, and there's no guarantee that it will work. It is their discretion. And if they use their discretion not to do it, you have no recourse. You can't file an appeal of that. You can't file a motion to reopen. And then you're stuck with exiting the country to try to get back into status. But you have to watch the 180-day clock, because if you have overstayed for 180 days or more, when you exit to try to fix it, you're triggering a 3-year bar. You have to wait for 3 years before you can apply for a new visa to come back, unless you qualify for some sort of waiver. If you've stayed for more than a year in that situation and then you leave, now it's a 10-year bar unless you qualify for a waiver. So it is very, very risky. Anytime your I-94 expires, make sure you talk with a qualified immigration attorney to understand your options, and make sure you consider that 180-day clock. Because if you have not reached 180 days yet, it may be better for you to exit, get a new visa, and come back in, versus trying the nunc-pro-tunc option and going over 180 days while you're waiting for it to come through.
One thing that I would tell people is that if your I-94 has expired in these two scenarios, though, do not contact the company lawyer, because the companies may tell you, we don't want to deal with you, we let you go. try to contact an outside lawyer. There are some solutions without filing with the USCIS. It should be spoken out one-to-one. There are some solutions. There are nice lawyers out there that can give you create solutions, but do not contact the company lawyer though before you speak with a separate independent lawyer. And as Emily has pointed out, do not walk into the CBP. They may detain you and send you to India after detaining for maybe a couple of days in the jail. So these two things, don't do it. First have a private lawyer consult and then have for the solution. Anything else, Emily, before we go to the next one?
Nope, we can go to the next one.
So I'm working with company A, Emily, and I have filed H-1B with company B, and I have not moved to company B yet. And company B H-1B gets rejected. I know I don't have any problem. I can continue staying with company A because I did not move to company B. Now, second scenario, Emily, is I'm working with company A, and now I file with company B. On the receipt notice, I join with company B. And now company B's H-1B gets rejected. What are the solutions for me?
So one option will depend on whether company A has withdrawn their approved petition. If they have not, and it has not expired, and they're willing to take you back, you could actually go back to company A and work in the same job you had before under all the same terms and conditions. So same work location, same job title, same salary, and all of that. So that's usually one of the safest options, easiest options, because it does not involve any additional filing with USCIS, and it puts you back into status as soon as you start working for the original company. If that is not an option, then we try to get a little creative about the 60-day grace period and say that, okay, company B's transfer was denied. I need to stop working for company B because I no longer have employment authorization. And that cessation of employment with company B starts my 60-day grace period. And maybe I can find a different company to file a transfer within 60 days. Or maybe company B can refile if they think they can overcome the grounds of the first rejection, and try that and try to use the 60-day grace period. It is a little creative. It's worked many times. There's nothing in the grace period regulation that says you can do that, but if you make a good argument, a lot of times USCIS will allow it. Other options, you could exit the country and then have a new company or the same company file an H-1B petition for consular processing. It does not have to go through the lottery because you've already been counted. Once you get that approved, you could use the old company's visa stamp if it's still valid and come back in, or go for stamping with the new H-1B and come back in. Any other options that I forgot?
No, you're good, Emily. Let's go to the last topic that we discussed about maximizing the H-1B, the 6-year period. Okay, let's assume that I got an H-1B approval in 2005. I came into United States. I didn't like it at that point of time. I left United States and I'm in India right now. Now things have changed and I want to come to United States. Do I have to go through the lottery system? Somebody said that you don't have to, but it looks like that person is a crazy person, because everywhere it says that it's 6 years. This crazy lawyer says that that no, you can come anytime. What do you say, Emily?
You can come anytime. I'm the crazy lawyer.
What?
And this is based on the 2017 regulation that made it very clear that there's no time limit on recapturing unused H-1B time, because it used to.
H-1B approval, Emily.
Say what?
It's 19 years ago I got the H-1B approval.
Yeah. And that used to be before 2017, the form would ask you, are you using a previous H-1B approval within the last 6 years? So everybody thought that it had to be within the original 6 years, like from 2005 to 2011 is the only time you can use that. Well, 2017 regulation made it very clear that that is not the case. You can use that 90 years into the future if you're still alive then, and get your remaining 5 years that you never used. You do not have to go through the lottery. Now, you could choose to go through the lottery if you want to get a full 6 years. So if you go through the lottery, get selected, now you get a full 6 years instead of just the remaining 5 years, or avoid the lottery and get your remaining 5 years. even 90 years into the future.
A lot of people have this because of the layoffs right now, Emily, and because what's going on in the perm delay. We see a lot of the people are exiting United States because they're coming close to the 6 years. Now, of course, they know that if they spend 1 year outside the country, they can apply in the lottery. And of course, we know how the lottery system works. It may be 1 in 4, 1 in 5, 1 in 10, 1 in 7. We don't know. And if you file the H-1B in March, and then you know the start date is October 1st, everybody knows that, Emily. But are there any ways, if I stay in India, can somebody file for us, and can some company file for my labor and I-140 when I'm in India and then still come back on the previous H-1B?
Yeah, absolutely. So neither the labor certification nor the I-140 require you to be physically in the U.S. in any status. So a company can sponsor you while you're outside the U.S. No problem with that. And then if they do, once your I-140 has been approved or your labor certification has been pending for 1 year, now you're eligible for additional H-1B time beyond the 6-year limit. So if you're going based on the perm being pending for 365 days, you can get a 1-year H-1B, consular processing, go for visa stamping and come back in. Or if you wait till the I-140 is approved, now the company can get a 3-year H-1B for consular processing. You go for stamping, come back in and get back to work on the H-1B, even if it's beyond the 6-year limit at this time.
Anything else, Emily, before we go to questions?
And with that, be aware that you can always file the H-1B up to 6 months in advance. So if your perm has been pending for 6 months and you know you're going to max out, you can calculate that max out time and figure out when you'll qualify for the next H-1B to start and file that 6 months in advance. And then you can go for stamping up to 3 months in advance so that you're ready to go as soon as your H-1B actually takes effect at the 1-year mark of your perm being pending.
Question from the I-485. Antanu Roy from YouTube has this question. He has a small accident, no injuries, no bodily injuries to anybody, nobody killed, of course, and no DUI, of course. That's good. Only citation for court. Will that create any problem in the 485, in the getting the green card approval? Absolutely not. Of course, if it's a citation, we want to know if you have paid a penalty of more than $500 for it or less than $500 for it. If it's less than $500 that you have paid a penalty for the court citation, you don't have to mention it anywhere. If it's more than $500, and since there is no bodily injury in this one, if there's more than $500 or if there is a bodily injury to anybody, you may want to discuss with an immigration lawyer. But if the penalty is less than $500 and no bodily injury, you don't have to mention it in the DS-160 form. You don't have to mention in the N-400 or 485 application about this incident.
Dia Cigar wants to know, why doesn't USCIS use the social security number instead of a passport number for the lottery? And are they going to be filtering out people that have multiple passports? So number one, you need to remember that the lottery isn't just for people who are in the US and have a social security number. Companies can register for anybody anywhere in the world, and anyone who's outside the US who's never been here before won't have a social security number. So they do need to go by the passport number. There's not really any other option for that. But yes, they will filter for multiple passports. They made it very clear. I can't remember exactly how they're doing it, but they're requiring you to use one passport and one passport only. And you have to enter on the same passport that you used for your registration as well.
Multiple passport, does it mean multiple countries passport?
I'm assuming multiple countries.
Just was doubting it. So Sahali has this question. How long it's taking for the 485 application to get approved? If the priority date is current though, we see quite a lot of those things getting approved immediately, the ones that are recently filed. But yes, it may take even 18 months for you to get the 485 approved when the priority date is current. But most of the cases we see are getting approved between 6 months to about 9 months to get the 485 approval. Yahoo
Me says the H-1B filed was was found in regular processing back on January 30th, and no receipt notice has come in yet. How long does it take to receive the receipt for an H-1B extension? I would say 2 weeks is pretty standard. If you can, I would definitely check to see if the filing fee check has been cashed or not. Most likely it should have been cashed by now. If it hasn't, that could mean that there's a problem. They may have possibly rejected it in the mailroom and have sent it back to the company, and that's why they haven't gotten a receipt yet. But if the filing fee checks have been cashed, there's nothing to worry about. You can even get the receipt number off the back of the cashed check in a lot of cases, but the receipt should turn up within 30 days.
Can I transfer me H-1B employer with the compliance review is ongoing with the current employer? Absolutely, you can. Even though compliance review is going with one employer, you can transfer to a different company.
Bhavani says, my I-94 is expiring soon due to my passport expiration, but I have the visa validity till 2026. Is it possible to renew my I-94 in the US without traveling outside the country and coming back? Yes, but if you are in an H-1B or an L-1 status where a company has sponsored you, the company has to file that extension. Basically, they treat it as if they didn't file the previous extension, so they've got to pay all the fees again. They may not be willing to do that. If you're maybe on H4 or L2 and you have to file an extension, then you can do that on your own or with your own attorney by filing the I-539 application. You don't have to travel. So those are two different ways to do it. But if it's based on a petition, the company has to be willing to basically refile the extension. Pawan says, advice on how much time it takes to transfer up my perm and I-140 from company A to company B. 2 years minimum right now, based on how long it's taking to get the prevailing wage determination, plus the amount of time it takes to advertise the position, plus perms are taking over a year. DOL has not approved any perms filed in 2023 yet, and we are in February 2024. We just got updated data as part of our perm lawsuit. I think there's going to be a deposition coming up pretty soon on that, which we're excited about. So we've got some movement on that case, and hopefully we'll get some answers.
I have a valid I-94, but I renewed my passport. Should I do anything on my end? As long as the I-94 validity, you're watching it very closely and it's valid though, if your passport is extended, you do not have to inform the USCIS at this point of time.
Samar says, I'm on EAD, AP, and changing my employer. Does my new employer have to file the 485J before I start with them? And how soon can I file my EAD and AP renewal? No, they don't have to file it before you start. We used to recommend that they just file it at some point before USCIS asked for it, but nowadays we just wait until USCIS sends an RFE asking for it to submit that. But no reason to file it before you start. It's not like an H-1B transfer that has to be filed before you join. As far as how soon you can file the EAD and AP renewal, about 6 months. We haven't had any problems with filing it earlier than that in most cases. Sometimes, though, they're approving the EAD renewal very quickly. And so if your current EAD is not expiring for a long time, they might say, you already have a valid EAD. We're not going to renew yet. And then they separate out your advanced parole, and that's taking 17 months to process.
Mr. Chaudhary has this question that his perm was being filed on August 30th, 2023, and his max out date, including the recapture time. Recapture time is the time that he has spent outside the country, is actually August 31st of 2024. And his H-1B actual H-1B is expiring on April 2nd, 2024. When he files the H-1B extension for those from April 2nd to August 31st, 2024, can he file for the 1-year extension based on the perm that would have been pending by August 31st by 1 year? Absolutely, yes. And there are a lot of lawyers who debate they cannot do it. They can do it. We have done it several times, no problems. There is an article published on my website. I published it You can look into it. We have done it several times. No problems anytime. And if the lawyer is not doing it, you may want to come to us. We will be willing to help you out on that. Tell them to point out to my article that's we have written rnlawgroup.com.
Cheng Liao says, would the I-765 based on a pending 485 get denied for someone who travels overseas while it's pending, even if they have H-1B status like the I-131 does? No, they don't deny the 765 for travel. You just have to be physically present in the U.S. on the day the I-765 was filed. But once it's filed, you can travel while it's pending, and it has no impact on the pending application.
From when does H-4s can start working without applying for H-4 EAD? No, they cannot. There is some confusion with regards to the bills that are there pending, where they are proposing regulations that are with regards to the H-4 people able to be working, though. That's not for the people who are not eligible for. That's only for the people whose spouse has an I-140 approval. There is no blanket provision that is pending right now that all H-4s can work. There is nothing like that, no proposal at this point of time. So you have to get your spouse I-140 approved. Then, under certain circumstances, if new things go on, they may be able to work without H-4 EAD. And that too, if you are eligible for 7th year or 7th year H-1B extension, and the spouse is eligible for 7th year extension, or the I-140 is approved. But no blanket H-4 EADs, guys.
Kaluri says, I've changed from H-1B to B-2. My B-2 is still pending. The end date I requested is May 22nd, 2024. If I don't find a job before that, what are my options? So you either need to exit the country by May 22nd, 2024, even though your B-2 is still pending. You can't continue to stay beyond the date you requested. Or you can file an extension of the pending B-2 and request from May 23rd, 2024 till October 23rd, or whatever 6 months is from there, to continue to stay. But if you do nothing and stay beyond May 22nd, that's a problem.
Yahoo Me, you already answered. I'm sorry.
Yeah.
Can I apply for a new passport for a change of address after H-1B registration? Why do you have to apply a new passport for change of address, though? You don't need to apply for change of address, new passport. That's driving me crazy, Emily. I'm getting some things that people are trying to do some fraud on these passport issues, though. Don't do that, guys. Don't do that, because they're not only going to track you with the passport, they're going to also track you with your date of birth too. So it's going to be overall tracking. Previously, the provisions were that it's based on, let's say Google and Apple applies, they would count you as two separate applications, though. Right now, it's going to be only one application. So if anybody is going to try to pretend that they are two different people, though, that by itself will be a fraud and will be banned forever coming into the United States. But I don't how passport need to be changed when you have changed the address. You don't need to change the passport.
No.
But go ahead, Emily.
Chirag says, I'm on employment EAD. If I get married to a girl in India, can she come to the U.S. on a dependent EAD? My priority date is not current. So by employment EAD, I'm going to assume you have the 485 pending and you are working based on your EAD that you got from that. In that case, no, there's no dependent EAD that allows her to come to the U.S. So she either needs her own status to come to the U.S., or you need to get into your own non-immigrant status like H-1B and then bring her on H-4. But there's nothing she can file outside the U.S. for her green card unless you're going to allow her to come in when the priority date is not current.
Vinay Kumar Reddy has a problem with his name. His first name is not the first name as the passport. His I-94 has a different passport first name. The passport has a different first name in there. Yeah, I understand your problem. Believe me, Vinay Kumar Reddy, I have the same problem. My first name is actually not Rahul. It is something else. And I went and it was a mistake that I did it in India, the way we write it, particularly in the Telugu states of Andhra Pradesh and Telangana, is that we write our family name, also called as surname, as first name, and our name as a middle name, and the last name Reddy. Typically, that's how it's written, though. So when I came into it, they asked me, "What's your first name?" I said, "It's Rahul," because that's actually my family name, not my name. My name is actually Venkat, but I wrote it down, and I still am living with my family name as my first name. So yeah, there are ways where you can change it if you want to. There are ways to change it. You may want to contact a lawyer to change it to see if what is the best way. Maybe when you apply for the next H-1B extension or when you come back to the United States in the I-94, you can do it. If not, you can officially change your name, saying that previously your name was Rahul Venkat Reddy to Venkat Rahul Reddy. You can change it. And then once you have the court document, you can show it, everybody will accept you. So there are two ways to do it. I choose to just forget it. I'm going to live with my family name forever. I choose that way. But it's up to you, which way you want to go. But I understand the pain that you're going through when I myself am in there right now.
Sunny says, is it a good idea to file the I-140 and 485 concurrently or separately? The priority date is March 10th, 2012. I think it depends on a few factors. I think in general, after October 2020, we started filing the I-140 first, getting it approved, and then filing the 485 because we felt that we were getting faster 485 processing compared to filing concurrently. I think that still applies. But what are the factors that you want to look at is how long is your priority date going to stay current? Because we had some times where retrogression was coming and we were afraid that if we waited for the I-140 to be approved, the priority date would move back and we wouldn't be able to file the 485. Now, in your case, it looks like through March, your priority date remains current. So if you file your I-140 in premium, you have time to get it approved and still file the 485 in March. But if you know that the date is going to go backward, then you could potentially file concurrently or file the 485 based on the pending I-140. Also kind of depends on what's going on with your non-immigrant status. If you have the time, your H-1B is not expiring anytime in the near future and you have time to wait for getting the EAD, you could probably file them separately. But if you are nearing the end of your H-1B and you want to get your 485 filed because you plan on changing companies within 180 days when you get your EAD, then you might want to go ahead and do the concurrent filing.
Questions from Viraj. On advance parole, can I only travel to India or can I go to Europe and come back on the advance parole? You can travel to any country in the world to travel. It's not limited only to India. Vijay has this question. He has recently traveled. His I-94 on the online says it's only valid for 1 year based on the advance parole. He traveled to the United States. So it's only valid for 1 year. But his AP is expiring in 2 years, which is the actual expiration. Definitely, it's the AP expiration date, not the I-94 date. You can still travel within the time of the advance parole, the one document or the card that you have, not the I-94. That is the expiration date for you. Arindan has this question. If the company supports the EB-1A, can we assume that it's guaranteed to get the EB-1A approval? Absolutely not. Just because the company supports the EB-1A, it doesn't automatically approve it. Yeah, it may help you to an extent. It may help you, but no, it does not guarantee you to get the. It does not guarantee you to get the EB-1A approved.
Hitesh says, in the new lottery system, can an employee know the H-1B case application number when the employer doesn't share it? They have not in the past. No, we don't believe so. I don't think that the employee has any access to the new online portal and they won't receive any notification. So it's going to be similar to before.
HPK has this question. If we file a Freedom of Information Act, that's when people request the records of their file online, will it be detrimental? That means bad for his green card application. No, it's not going to be bad for you in getting the green card. Abdul has this question. How soon can we apply citizenship after we get the green card? Well, there are two normal categories which people are in. If you are married to a US citizen for more than 3 years, for up to 3 years now, you can file in 2 years, 9 months, and 2 days. Within the 3 year period of time, though, 90 days before the 3 year period, you can file. Not 91 days. If you file 91 days before, they will take your money, spend 1.5 years, and they will deny your application. If it's 92, if it's 85 days or 87 days, though, it's perfectly fine. So I normally tell people file at the 80th day, somewhere around that period of time. You can do it. Now, when it comes to those people who are not married to U.S. citizenship, it's typically is 5 years for them to get for them to apply citizenship, but they can apply within 90 days. They won't get the citizenship, but they can make the application within that 90 days. Not 91 days, but 85 days is good. And citizenship applications nowadays, guys, you can file it online.
Slow Shali says, would a change in address impact my green card I-485 application? Yes. I mean, number one, when you do change your address, you do need to file the AR-11 to notify USCIS of your new address so that you can get mail from USCIS to your new address and your green card to the new address. But also, yeah, they may move your 485 from one office to another based on where you actually live. So it can impact it in that way, but regardless of whether it does impact it or not, you still always need to update your address with USCIS when you have a pending 485. HBK says, can filing a FOIA request be detrimental towards your future visa or green card applications? Definitely not. It's your right to do. Anyone can file a FOIA request to see what information is in their files, and it does not have any impact. I don't even think USCIS or Department of State or Department of Labor sees that at all. I mean, it's kind of a separate office that responds to those. So I can't imagine any reason why that would cause a problem.
Arvind's H-1B visa stamping has expired. His advance parole, he got it for 5 years as normal. Can he go to India on advance parole and come back and continue working on the H-1B? The answer is yes, you can. Yes, you can.
FTC Robotics said, what document should I keep as proof that I have my I-140 approved? Well, generally, it would be your I-140 approval notice. That's the I-797 that says your I-140 was received on X date, approved on Y date. It'll say what your priority date is and what SOC code you had. But if the company's not sharing that, the next best thing is to do a FOIA request to get a copy of your approved I-140. They'll actually give you the I-140 forms that your company filed, and it'll have USCIS's stamp confirming it's approved, and it'll have the date of approval, your priority date, and your category. That works just as well.
Gapa has this question from YouTube. When somebody gets the H-1B, they feel they're very happy. Then after 4 or 5 years of the H-1B, they see no future for the green card. They realize it's a curse. That's a typical dialogue. I use it. You may be right on that. I mean, I can't deny what you're saying. One thing that I would suggest you is that if you want to, if your I-140 is approved, though, if your I-140 is approved, you can think of actually going to India and coming back at a time when the date is correct. So you don't have to stay in this country. A lot of people say, oh, can I come back after 10 years? Can I come back after 20 years? Can I come back after 30 years? Yeah, you can. I mean, you can. The main criteria is that if H-1B need to be counted, and if you get that additional I-140 approval, when you can go to India and then decide whether you want to come back later on, and when the priority date is become current, you can come back and don't have to deal with immigration laws much at that point of time. You can choose to do so, not a problem.
Pranav says, how are the I-864 thresholds assessed for a marriage-based green card when the couple's been married for a while and are filing joint tax returns where one partner is on an H-1B? So they look at what is your current household annual income, and that has to be greater than the I-864P number for the number of people in your household. Now, let's say that the U.S. citizen who's filing the green card doesn't work and is married to an H-1B holder, and the H-1B holder is supporting the household. Because the H-1B holder's income is lawful, you can use the H-1B holder's income to prove that you have sufficient means for your I-864. So I don't know if that answers your question, but you can take into account the intending immigrant's income as long as it's derived lawfully.
Question from Ritesh Singh Thakur. His daughter is turning 21 on June 2025. What is the right time for her to get to apply for the F1 visa, those people who are turning 21? We recommend, though, 1 year before graduation for sure. That would be very ideal, and do it in premium processing. That's what we advise people. 1 year before the graduation, that's for sure. But what if they're graduating after 21? And the other thing is probably 20 years, whichever is the earlier one, either third year, second semester, or when they turn 20. That's the time. Whichever is the earliest, I want you to pick. There are a lot of reasons why I pick. We need to make sure that they get the OPT, and the OPT also after they graduate. And we also have to give some time just in case if there is an RFV, we have enough time to respond to those things. So 20, when they turn 20, which in your case is June 2025, June 2024, or third year, second semester. Either of the, whichever is earlier, you pick that one.
Vipin said, is there any relationship between the current H-1B and the I-140? Will USCIS ask any questions about my current H-1B when submitting an I-140 petition? No. Remember, the I-140 can be filed for anyone, anywhere in the world. There's no requirement that you be on H-1B or even in the United States, so they don't ask that. Now, there's questions on the form that asks what's your current status if you're in the U.S., what's your current last date of arrival, and when does your status expire, but we don't even submit documents to show you're maintaining status in an I-140 because it's not relevant.
Vijay is asking this question. His I-94 expires and his AP validity is still there. He traveled on advance parole. Absolutely, you can stay in this country. Actually, your stay is not determined by the advance parole. It's determined that your adjustment of status is pending. But anyway, to answer your question, your advance parole is still valid. NP has this question, very interesting question. After receiving the I-140 approval, of course, after being H-1B for a while, let's say I move to India. In order to come back when the priority date is current or about to become current, doesn't the employer need to file a labor and I-140 again? No. The employer needs to file only H-1B for you to come into the United States. So once you come into the United States, of course, for you to get the green card, though, the new employer need to file a permanent I-140 approval. But for you to come into the United States, you do not need the POM, you do not need the I-140 from the new employer.
Zorav says, will there be a problem if I took 30 days of unpaid off for a vacation in the U.S.? I'm on H-1B and my perm is pending. For the perm, there's no issue at all. On the H-1B, there could be, depending on the motivation behind your unpaid vacation. If, for example, your company said, hey, your project is ending tomorrow. I don't have a new project for you. I need you to take 30 days of unpaid vacation. That's a problem. No, you can't do that. That can be a violation of status. The company is violating LCA rules. They can get into trouble. You can get into trouble. So really depends on what the reason is behind the unpaid vacation. And if it's something where all of their U.S. workers have that same option to take a 30-day pay on vacation that has nothing to do with work being available, then maybe it's okay.
Question from Andhra to America from YouTube. This gentleman is a doctor from Hospital X, filed EB-1A, got an RFE, provided supporting documents for a hospital reputation, to provide supporting document for a hospital. So do you have any suggestions how to respond? Definitely, you can respond to that. I would recommend to contact a lawyer. In our office, the best person is Kareem. In fact, today he just got an EB 1A approved for a French guy on some RFP that he received, which he just was telling me about it. So you can contact him. He would be able to help in drafting the response.
Sandy says, is there a way we can utilize or make an H-1B approval effective with a future date in order to utilize OPT status? Yes and no. So the way to do that is to have your employer file consular processing for your H-1B once you're selected in the lottery. That means you're going to get an H-1B approval that does not actually change your status from F1 to H1. So you can continue on your OPT, and then when you're ready to switch over to H1, you can exit, apply for the H-1B stamp, and come back in, or have your employer file a change of status to H-1B later. However, it may not be the best idea to do that. Number one, is it the company who's recommending this, or are you wanting to do it? Because when the company's recommending it, it's usually not in your best interest. Number one, they're getting a tax break on it, which has no help to you. But number two, you can't predict the future. You don't know if this job is going to exist 3 years from now. So what if you do your consular processing H-1B, and then 6 months from now, that employer says, hey, sorry, you're terminated. Now you don't have an H-1B. Now the 60-day grace period doesn't apply. And you can't use that H-1B to transfer to another employer because you haven't actually been counted in the lottery yet. So there's a lot of downsides to doing it, even though, yes, it's technically possible.
Emily, I have this question. I need your attention on it. Agrim Rocks has this question. He's on adjustment of status EAD. Can he work on entirely stock options, zero salary? Now, I will tell you one thing though. If he is a dependent, EAD though, I think so. There may be some labor minimum wage requirements that we are not aware of. As far as we don't have much knowledge about it. But as far as the immigration is concerned, we don't see any problem in it if the person is a dependent AOS EAD. But if the person is the main applicant, though, can they do it, Emily, on just a stock option? I am thinking that it may not be appropriate. He may be risking his 485. Please correct me on it.
No, I agree with you. I think that's it has to be a permanent offer of employment, and the company has to actually offer to pay some kind of wage, just like they would if they had to file a labor certification or I-140 petition on your behalf. I think that would be very risky.
Ram has this question that came to USA with company A in 2018 and went back to India and stayed there for 1.5 years and then came with a fresh H-1B lottery. Does he have to count the 1.5 year that he stayed in? Can he get all 6 years? Now, since you stayed 1.5 years there in India and you got the fresh lottery, you now start the 6 year all over again. You now all over start again. But I don't know why you have actually gone through the lottery system. You didn't have to go through the lottery system, but luckily you got through the lottery system. That's fine. You get all 6 years again. And that 1.5 years will not be counted towards the 6 years. Since the time you came back from the last time, the 6 years starts all over again for you.
All right, well, I think we are out of time for today. Thank you everyone for joining us. Don't forget that we do have a free daily Zoom call where you can join and to get your questions answered. You can go to rnlawgroup.com to get the information for that. And don't forget to sign up for our newsletter as well so you can get the latest on all of our articles that we publish every week and find out what's going on and stay on top of all the immigration updates.
Thank you very much for tuning in.